Hi everyone, I'm attorney Aiden Durham with 180 Law Co. in Colorado. Welcome back to All Up in Your Business, where we're going to be going through your comments and answering your trademark questions. Before we get into all of your great trademark questions, I have three very important announcements. Announcement number one, it's really more of a request, but whatever. If you're new to my channel or if you haven't already subscribed, now's a good time to do that, and make sure you click that little bell so you get notified anytime I post a new video. Important announcement number two, I got a new Britney shirt from Target and I think it's pretty sweet. An important announcement number three, you can find answers to all of your trademark questions in my free guide, the Brandish Ultimate Trademark Guide. You can download it for free by clicking the link in the description. All right, let's get into your trademark questions. Hi, we have an LLC since 2019, and this week doing a search on the internet for our company name, we find out that the other company has our exact name in a different state. We offer the exact same services. What do I need to do? You don't need to do anything. What you should do is consult with a trademark lawyer because there are a lot more details in here that we're going to need to know before we can say really what you should do. So talk to a lawyer. But what would I do? I would first see if that other company has registered a trademark with the USPTO for the name, because that will impact your options and what you do. I would also look into when they started when their company started, which if they have a trademark registration, it would say their date of first use there. And so that would give you an idea of who has first use here. But so it's going to come down to those two things. If neither company has a registered trademark, if they don't have one, but they've been using since before you, it will kind of come down to common law rights, and those are usually restricted to your geographic scope where you've been using the trademark. All kinds of stuff comes into it. So it depends. You should talk to a trademark lawyer. Like actually consult with one, not just leave a comment on YouTube. Hi there. I was wondering if I'm outside of the US, to what organism should I go to do the trademark registration process? I think that's supposed to be organization, but I like organism too. If you want to register the trademark in the US, if you're using it in the US, then you would go to the United States Patent and Trademark Office at USPTO.gov to do that trademark registration. If you're outside of the US, it's going to be whatever agency, governmental body handles trademark registrations in whatever country you want to register in. Every country has their own trademark system and agency. I don't know all of them. So how do you register a copyright to protect your designs? Do trademarks only protect the logo itself? So I think this is getting to the idea of a logo being a trademark and being protectable by trademark registration, but a logo also can sometimes be protectable by copyrights if it has enough artistic, creative expression in it, which certainly happens, but it's not every logo is also a copyright. Doing a trademark registration protects the trademark. In this instance, it's the logo. So yeah, trademarks protect the logo. There might be elements to it that are also protectable by copyrights, and copyrights would protect those elements, but in a very different way than how the trademark does. So you register the copyright at copyright.gov, the US Copyright Office. And then yes, trademarks only protect the logo. To clarify, the first use of a trademark is the first sale of a product or service between state lines or to another territory or country. Yes, for the most part, that's an easy way to think about it. That's not, so you have to have interstate commerce to be considered use in commerce, or interstate or over to another country or territory to be considered use in commerce for purposes of getting a US trademark registration. And so interstate, between state lines, that's not always, it's not always clear black and white though. There are instances like with a restaurant that might be located in just one state. You might think, well, they're only serving people there. That's not interstate commerce, but people travel from out of state to get to that restaurant. So it's generally generally accepted, like for restaurants, that's usually considered interstate commerce. So again, it's not totally black and white, but yeah, sale of a product or service between state lines. That's your date of first use. Usually. Again, there's more to it. Like nominal sales, like if you just sold one product to your friend who lives in a different state just for the sake of making the sale, no, that doesn't count. But generally, yeah, the answer is yes. So are you suggesting that you have to already be using your trademark idea openly before filing? No. So how do you keep people from stealing it and filing it before you? No. So you have to be using your trademark in commerce before it will get registered. So you have to be using your idea openly before the trademark will be registered. You don't have to do that before filing. You can file on a 1B intent to use basis to kind of get it protected and stop people from filing before you if you want to do so before you start your business and start using the thing openly. I just had a quick question. I don't know if you have a phone number. I know you said you can't give legal advice, but this is not legal advice. We'll see about that. This question is, I am just doing funny videos on YouTube or TikTok. Do I need or should I register a trademark on that stuff? Or is it even necessary? That's a simple question, I hope. Quick questions never have quick answers, you guys. So I don't on that stuff. Depends, number one, on what you mean by that stuff. Your videos aren't. I shouldn't say can't. Your video content isn't a trademark. There are ways you could maybe use it as a trademark, but no, your videos aren't protectable by trademarks. Those are copyrights. You could register the copyrights to kind of protect your copyrights in those videos. The name, I guess, or your handle of your YouTube channel or your TikTok account, those could be considered trademarks. So you could register those. Do you have to? No. Is it a good idea? If you want to protect them, registering the trademark is a good idea. Hello, Aiden. If the name New Phase Lifestyle Nutrition is a trademark, can I use New Phase Nurse for IV infusion? I'm assuming New Phase Lifestyle Nutrition is being used for nutrition-based products, and New Phase Nurse is IV infusion. So just based on the names alone, no other information, I'd say there's a good chance just based on the names alone that they'd be confusingly similar, and the USPTO wouldn't register it. Now we have to factor in the goods and services. Nutrition is, I could see the USPTO seeing that as closely related to IV infusion because they both are vitamin related, vitamin supplements. Those IV infusions are vitamin supplements basically. Yeah, I don't think you would get that registered if Nutrition Life Stays Nutrition or New Phase Lifestyle Nutrition is already registered. Yeah, I don't think you'd be able to. No, they're definitely confusingly similar, and the USPTO wouldn't register them. I mean, you're got other ways around it, but no, just based on that, I highly doubt it. You should talk to a trademark lawyer though. Question. I want to register a brand name in 3 classes. However, I do not have the symbol logo ready yet. Is it possible to register the brand name now and the logo later, or does it make sense to register both at the same time? Absolutely makes sense to register the name now and you can do the logo later. It's best to do, to apply for all your trademark registrations and as early as possible, but that's not always, you can't always do a bunch at once. So yeah, that's fine to do the name now and then do the logo later whenever you've got the time and resources available to you. Hello, am I able to trademark a name and logo at the same time? Absolutely. Yep. Well, not in the same application. They're 2 different trademarks, so do 2 different applications, but yeah, you can submit them at the same time, same day. Okay, but on the USPTO, they want me to pick a particular product like t-shirts. What if down the line I want to diversify? And I certainly would. What if I want to get into sporting goods? Anything else? You can still do that just because your trademark registration is only specific to t-shirts. That's not preventing you from selling whatever else you want to. As far as registration planning, you can apply for all the other products on a 1B basis, and the t-shirts would be on a 1A basis. So that way you're starting the protection for the t-shirts right away, and then you're kind of taking your foot in the door and slowly starting for the other products, assuming you're going to start selling them in like 3 to 4 years. What's better, a trademark or copyright for a phrase, motto, or slogan? As long as you're using it as a trademark, so you're using it as a brand identifier or something like that, then a phrase, motto, or slogan is a trademark. They're not really copyrights. I guess they could. There are some instances, but no, those things are trademarks, not copyrights. I left this one in. It's not trademark related, but I thought it was just an important question. What if you hire an attorney and you don't like the way they work? What do you do? This is a great question. I'm sure this happens all the time. I'm sure that I have some clients who wish they hadn't hired me. I'm just kidding. All my clients love me. So the first thing, if you feel comfortable, tell your lawyer. Tell the lawyer what is bothering you, what you're unhappy about, ways that you would like to see your relationship with them change. If one of my clients said something like that to me, it would be very important. I want to make sure I'm serving my clients the way that they want to be, and that I'm making their experience with me the best I can. So if there's some way that I can improve that service, I would love to hear that from my clients, assuming you're comfortable doing that and all of that. If they ignore you, if they're offended, if they, don't like it, if for some reason that doesn't solve the problem, then you can fire your lawyer. I guess there might be some states where this isn't possible. No, you can fire your lawyer whenever you want. You're not like bound to a lawyer. You may have some contractual obligations. You may not be able to get like a refund of all of your fees, but or any of your fees really. But you can fire your lawyer whenever you want and go look for another one. You don't have to feel bad. I mean, don't be rude about it unless they deserve it. But yeah, you don't have to work with a specific lawyer. You can change to any other lawyer. Okay. Thank you all so much for your great comments and questions. I hope you learned a thing or two. Give me a thumbs up if you did, or just give me a thumbs up if you like my new Britney shirt. Don't forget to check the link in the description to download my free Ultimate Brandish Trademark Guide. So many more answers to so many of your questions. Thank you all so much for watching. I'm Aiden Durham, and I'll see you next time.